the Bar Council in this matter. This matter is before the Court on Bar Counsel's appeal of an order of the single justice suspending the respondent from the practice of law for 3 years, with the third year that suspension stayed. The issue before the Court is whether trust funds paid as retainers should be treated differently than other trust funds. It is Bar Counsel's contention that no distinction exists and that all funds entrusted to a lawyer should be treated the same. In the current matter, the respondent and James Edgerston, who was her client, entered into a written fee agreement requiring Edgerston to pay the respondent a $10,000 retainer and requiring the respondent to deposit that retainer into her trust funds account. The agreement further provided that the respondent could use the funds to pay her fee of $155 an hour, but only after sending Edgerston billing statements detailing the work done at least 2 days prior to withdrawing any funds. Edgerston gave the respondent the $10,000. The respondent, however, did not deposit the money into a trust account. In fact, she put the money into her operating account. And within 3 weeks of that money being deposited into the operating account, that account had a negative balance. And the money had been spent on business and personal matters unrelated to Mr. Edgerston's case. In fact, the respondent never earned the money, and the only work that she did do was done incompetently.
If we can go back to your basic premise, which is that they should be treated the same as client funds, Mr. Burson in a moment will come up and say there's a fundamental difference between a retainer, which is essentially an advance on money the attorney expects to earn and therefore become hers, versus client funds, which will never and should never become the funds of the attorney. Why is that distinction not enough for us to treat retainers differently from client funds?
This was one of the factors that the board looked at when it decided that retainer funds should be different from something that they've characterized as classic client funds. The argument ignores the fact that there is often an agreement to give an attorney interest in trust funds, such as settlement proceeds or estate funds, that both the attorney and the client have an interest in. Here, in dealing with a retainer, there is an expectation that the funds will be earned. But at the same time, the funds themselves do not lose their nature as client funds. They remain client funds up until and unless the fee is earned. And to draw a distinction, as the board has done, and the board has said in drawing that distinction that this court has never spoken on the issue of whether or not there should be a distinction between retainers and other types of trust funds. But in drawing that distinction, the board overlooks the fact that there are funds that are given to lawyers that are to be divided between themselves and the client. And again, the example that I will use is trust funds. I'm sorry, strike that. That funds obtained from the settlement of a personal injury case or estate funds. There is no dispute that the conversion of those clients' funds or the share of the attorney's share of those funds would be subject to the presumptive sanctions and 3 attorneys and chauffeur that this court has set out and reaffirmed time and time again.
Your position, I take it, is to the extent that the board says, well, we would treat them the same, except there's a bunch of confusing, the point that you and Justice Gansler have just been discussing, but beyond that, it's just not clear. It's not very clear. There's sort of confusing signals being given, I think that they sort of suggest. But I take it your answer to that would be, well, these retainer funds, like classic client funds, have to be put into the IOLTA account under 1.15. And to the extent that somebody might argue, well, it's confusing because money advanced for expert fees or something are treated differently, but they don't get put into the IOLTA account, correct?
Monies for expert fees, monies for expenses don't have to be placed in the IOLTA account, but if you look at the definition of trust funds in 1.15, they still are trust funds, and the lawyer has...
No, I'm agreeing with you. I mean, I guess I'm just saying one way of clarifying if there is confusion is that the rules draw this distinction between what has to be in the IOLTA fund and what doesn't. And you would say that what has to be in the IOLTA fund is basically client funds, whether it's retainer to be earned or a settlement account. Whatever.
That's correct. They are trust funds, and the rule itself, Rule 1.15, very clearly defines them as trust funds, and there simply is no reason to distinguish between a retainer as trust funds and client funds as trust funds for the purpose of Rule 1.15 and depositing those funds into a client funds account.
Well, surely your point is that the same presumptive sanctions ought to apply. I mean, it is a violation, of course.
Yes.
And some sanction will apply.
Some sanctions certainly do apply. In fact, if you look at some of the cases that have been cited by the board in its memorandum, they are reasonably consistent with the presumptive sanctions suggested by Chauffeur and by three attorneys. In those cases where there is no deprivation, an appropriate term suspension is imposed. In those cases cited by the board, there is no deprivation. The sanctions that Bar Counsel suggests imposed here are similar to the sanctions that this court has affirmed time and time again, both in three attorneys and then in the Chauffeur case. And those presumptive sanctions deal with the misuse of trust funds. And I think, as Justice Botsford points out, there's no difference between retainer funds and trust funds. They are the same animal. They're the same creature. And if you look at the rule defines, Rule 1.15 defines them as the same types of funds.
Mr. Warner, the respondent here had been practicing law for 3 years.
I believe that's correct.
Was she a solo practitioner?
She was a solo practitioner, yes.
Why shouldn't some consideration be given to the fact that there may not have been sufficient experience here?
If you want to consider that, then that might be considered as something as mitigation, more than it is something to remove the misuse of a retainer funds from the presumptive sanctions that exist under Chauffeur. It may be a consideration. In fact, in Chauffeur, this court recognized that a respondent attorney bears a heavy burden. I believe that's the language that the court used. Bears a heavy burden to undermine the imposition of the presumptive sanctions. What you're suggesting, Justice Spina, is that that may be a fact that a hearing committee or a board or this court might consider as something that is part of the burden that a lawyer has to bear in order to avoid the presumptive sanctions that are suggested or that are suggested in Chauffeur and that should apply to retainer fees.
So do you agree that if we adopt your interpretation or your approach to these kinds of funds and hold them to the same standard as the matter of Chauffeur in three attorneys' cases, that even if we do that, under the facts of this case, we could still reach the same sanction as the single justice did?
It's possible, but if you look at the reasoning of the board, and the single justice didn't write a memorandum in this case, so we don't have any way of knowing what the single justice thoughts on this were, so we have to look at the board memorandum. And if you look at the board memorandum, what they talk about is although they accept the mitigation in the conversion, they discount it with respect to the other misconduct. So if you wanted to consider it as a mitigating factor, it's conceivable that this court could come up with the same sanction imposed by the single justice. But it should do it under the guise of that there are presumptive sanctions and that the...
It's just facts of this case suggest mitigation.
Exactly, Justice Botsford. It's just another fact in the case that needs to be looked at. And it's not... It doesn't remove the case from that ambit of presumptive sanctions that Chauffeur suggests should be imposed for the misuse of client funds.
Now, with regard to what the board refers to as a classic retainer, I assume that can be spent without being earned.
But if the client then says, I want the money back, or if I think you're talking about the classic flat fee or the classic, I'll give you $10,000 That's my flat fee.
No,
In criminal
I'm
kind of
referring to
setting.
the classic retainer that the board refers to is, I will pay Skadden $10,000 a year to make sure that when I need them, or if somebody else wants to use them against me, they won't be able to. That's what it refers to as the classic retainer.
That's the classic retainer, that's correct. And in that case, the classic retainer can probably be spent by the attorney. But if the work isn't done, and if the client then says, look, I've decided not to employ you as my counsel any longer, and the money has to be returned, then it's a question of really a 1.16 situation where there is the return of the unearned retainer, and it's not necessarily a conversion of a client funds type of a case, which is what the facts that this case presents.
This case has, in addition, I mean, arguably, even if one were to draw a distinction between retainers and other types of client funds, you have a specific agreement here that she was supposed to get permission to do this.
That is
before she
correct.
took it.
In fact, the agreement obligated her not to remove the funds until she had sent a bill to the client and waited at least 48 hours to give the client the opportunity to object to the fee if he chose to do so. But what happened here was that the money was immediately deposited into an operating account, and within 3 weeks was gone. And she hadn't earned any of that money by that time. And as I said, whatever work she did do turned out to be incompetent work. She didn't stop the foreclosure proceeding that was going to occur. The complaint that she filed in the federal court cited a state of Washington consumer protection law, which had nothing at all to do with the transaction, the underlying transaction that was the basis of the lawsuit. And in fact, there was a state claim that was ultimately filed.
I guess jurisprudentially, why is it so important that the presumptive sanctions be imposed in this circumstance? Why is it not enough to say it's a serious violation, it's a breach of obligation, it'll be severely sanctioned? But why must we move to the presumptive sanctions of chauffeur and risk essentially devaluing the currency of chauffeur by having so many exceptions that it begins to devour that rule?
Well, I think that, in answer to your question, I think it's important for lawyers to know what they can and cannot do with funds that they're entrusted with. Retainer funds are no different than client funds.
Right, but I guess my question is, why can't we do that by saying it is a violation of trust, it'll be severely sanctioned? But why must we go as far as you ask and make it a presumptive sanction of disbarment and indefinite suspension?
I think the simple answer is that retainers are trust funds, and that this court has, after backpedaling a bit from three attorneys and carving out exceptions, finally in chauffeur saying, all right, look, client funds are going to be treated very seriously. Retainers are client funds, and there's no reason why retainers should not be treated in the same manner as other client funds. I don't think you need to go to law school to understand that if you take money, you're obligated to earn it. If you don't earn that money, you're obligated to return it. If you convert that money, you have misused that money. And what Bar Counsel is saying is that these standards that we talk about, these presumptive standards that can be overcome by an attorney who bears a heavy burden to overcome those sanctions, those presumptive sanctions have always or should have always been applied to retainer fees because they are trust funds. And when you look at the rule, as I said earlier in my argument, when you look at the definition of trust funds in Rule 1.15, it is clear that retainer funds are contemplated as being trust funds. And if in fact they are, I suggest to the court that they are trust funds, then there's no reason to exclude them from the presumptive sanctions that are imposed or that are suggested in chauffeur.
And would you propose the same rule if these were advances for costs and expenses?
I believe that's the next case that the court is scheduled to hear, but those would also be considered trust funds, and that same rubric that's used in chauffeur should also apply to those.
Even though the rule allows them to be kept in a business account?
It allows them to be kept in a business account, but still considers them to be trust funds, and that's really the key point here. One last thing I would say is that there is additional misconduct that this court should also look at. The respondent falsified letters to Bar Counsel. The respondent neglected 2 cases, resulting in the statute of limitations running on them, and it harmed her client. Thank you for your time.
Thank you, Mr. Warner. Mr. Gerson?
May it please the court, my name is Mark Burson, and I represent Tammy Sharif, and I have represented Ms. Sharif at the hearing panel level and before the BBO, and as well as before the single justice in this case, and I'm privileged to do so here.
Mr. Burson, if an attorney misuses client's money, whether the attorney does so because, whether the money is client is a retainer, or whether it's money that's supposed to be applied to fees, what's the difference? The issue is that the attorney is misusing the client's money.
I would agree in part, but where the case hits the ground is in the practicality of the application of it. First of all, trust funds, which I'm old enough to know as escrow funds, are held in the IOLTA account, usually for
what? What difference does it matter where they're held or how they're held? It's money that the client entrusts to the lawyer.
Yeah, give me a chance. They're held differently. First of all, the trust funds usually are designated in circumstances that arise out of real estate transactions, estate transactions, and so forth. And what's involved there is a designated amount of money going usually to a third party, such as a bank, to pay off a mortgage, to pay off a beneficiary. So you have not just the 2 parties involved, you have a third party, and I think the minute you trigger the third party, you trigger the public. And that's what the whole business is about, protecting the public. When you get involved in retainers, as we have seen in the briefs and in the discussion, they have multiple uses, and they also result in multiple allocations for expert witness fees, for the fee incurred, and also for the retainers in order to refund an unused retainer. If the court adopts this hard and fast rule that all fees are regarded with the sanction of disbarment, I think that's what the case is about. What I'm here about is that if this court adopts this mandatory sanction, what you have here is minimum maximums. You have the Bar Council being put into this process in a position that nobody else has, because once this occurs, the whole tenor of the case going through the system means that and I refer to my brother affectionately as the prosecution, the Bar Council in this has a leg up on the hearing committee, has a leg up on the Board of Bar Overseers, and I would suggest respectfully has a leg up on the single justice, because there was no dispute here as such as to what happened. Where the case was litigated was in connection with the mitigation.
But Mr. Burson,
that's a different issue. Mitigation.
Pardon?
Mitigation is a whole different issue. There's nothing to do with what the penalty should be. And I'm sorry, I just can't follow why, if someone misuses money that belongs to the client, why it matters how the money is characterized to begin with.
Well, I think that when you get money as a retainer, there's a little more to it than just designating it as a particular fee that's going to a particular event, and mitigation is in my view is what this case is about. Relative to the sanction, mitigation and the violation go hand in hand, because without it, there's no use of having it. And this case cries out for mitigation.
What is the mitigation here?
The mitigation here is, first of all, as Justice Spina pointed out, is this was a solo practitioner who was very young, whose history.
That gives somebody a license to take somebody else's money? I mean,
No,
doesn't one know that anyway?
No one's giving anybody a license to take anyone else's money. It's a matter of the sanction and the circumstances that happens. Courts, as well as the hearing panel, as well as the full board, as well as a single justice, took into consideration what had happened and what the individual circumstances are in the particular case. I think it's well settled that every one of these cases is sui generis. You have to look at what happened, what the sanction should be, taking into consideration mitigation. The mitigation here is overwhelming. This woman has a tremendous personal story. What she overcame in her life resulted in an encapsulating depression that wasn't broken until she got antidepressant medication. And once she did that, she recognized and realized what has happened. Not only that, she has made restitution to these individuals, so the harm is somewhat mitigated. She has been sanctioned, and I think appropriately sanctioned, through a process that looked at the situation. It went from level to level until it reached the single justice, and everybody weighed what the factors were in connection with her plight. We did not contest from the get-go what she did. What she did was horrendous. It's not to be excused. But if you look at what the hearing committee heard the case, saw her, and so forth and so on, in I think it was 49, finding number 49, when they connected the depression to the conduct, they didn't excuse her. They sanctioned her. The board sanctioned her. The single justice sanctioned her. Everyone looked at it somewhat differently, but they didn't do so without imposing a very, very severe sanction. If we have a presumptive sanction that money that's taken out of an account is going to result in disbarment automatically, then there's no use in trying to save this individual. This person is an important individual. She is an African-American lawyer in Holyoke and in Springfield, and she has represented criminal defendants, indigent criminal defendants, and juveniles, and that is something that's not so easy to come by in this day.
Isn't really what you're saying that presumptive sanctions create a lot of collateral damage, and I would like to limit the use of presumptive sanctions. It's not really that there's a distinction in its money. It's just that presumptive sanctions carry with it a lot of bad consequences, and in this case, in your view, very bad consequences.
Amen to that. Absolutely. Because I don't think there ought to be a presumption of sanction, because how do you exercise any kind of balance? That's what courts do. That's what the panel did. That's what the board did. That's what the single justice did. How do you think about it, deliberate it, take it into consideration, recognize the human condition that existed, and make a determination that fits the situation? In addition, what the basic tenet of all this business is to protect the public. All these rules are to protect the public. The public here was protected. The violation was brought to the attention of Bar Council. It was handled. prosecuted, heard, reviewed, and further reviewed. And let's remember that this process of protection also means that Ms. Sharif has to reapply in order for reinstatement. It's not just automatic without that process. That process, to my knowledge, can take anywhere from 18 months to 2 years. So we're talking about an effective or real sanction that amounts to approximately 3 years or perhaps 4 years before she's able to resume her practice. And as I had urged below at the hearing committee level, that I would have liked her practice to be restricted to what she felt she was competent to do, because once she got outside, I think the stresses just destroyed her until she got help. And she's exhibited, a tremendous amount of turnaround. I think she can be redeemed, reclaimed, and otherwise, if she is hit with this mandatory sanction, which amounts to 5 years and it turns into 7, I think she will have an incredibly difficult time to recover. I would also make the point, which is a point, is that there is confusion, or was confusion, and I guess that's why we're here to reconcile this confusion. And if the court should adopt this sanction of disbarment, that it ought to be done in a prospective way and not in a retroactive way, because I think that is basically what we've been about in this business for a long time, and it would be rather, I think, extremely harsh for her to suffer this penalty on a retroactive application.
Now, on a different front, the hearing committee said that during probation she should be limited to juvenile and criminal matters. Did the board carry over?
No, it didn't. The board did not do that. The board basically took the position of imposing the 3 years sanction and the single justice. The single justice
now he has probation
modified.
again.
Pardon?
Right. But now he's put probation back in.
Right.
And
right.
Is that a condition of the probation of the single justice or not?
I don't believe so. I think part of that is just that the board doesn't have maybe the facilities that they should to implement it. That's something that we sort of have to cobble together for the particular respondent, because you have to get people outside the usual BBO framework to come in and act as supervisors and mentors. Although in the case initially before the panel, there was an individual who was a senior member on the bar advocate panel in Springfield, who was willing to do that, who also suffered from depression and came back, and I thought that he was somebody who could really relate to this particular lawyer in that context. But to answer your question, I would urge that be the case, and that's why I suggested below that the monitoring take place, and that there be reporting by the healthcare or mental health professional directly to the board that she was attending, and she was on task, and she was complying in connection with the medication regime and also the psychotherapy regime.
Okay, thank you, Mr. Burson.
Thank you. Nice to see you.